Welcome to the Education Law and Ethics presentation. First of all, I'd like to thank my administration for having given me the opportunity to do this. I also thank the new teachers for being part of this program. It's really a good opportunity for you new teachers to get involved in the education of, into the law and education of public education. So first off, we have our students' rights, and what I have come to the conclusion is that the courts will rule in favor of students' rights, and they'll rule in favor of the school district as well. According to Summers, Karakoff, and James, students are forced to attend school, so the courts really cherish their First Amendment rights. And another case that would make teachers liable for student speech in Wood versus Strickland in 1975 said that teachers may be liable for limiting free speech, and if they do not suppress certain lewd and lascivious speech, then they could be liable for that. Some speech is limited. The Fourth Amendment in schools is protected by unwarranted search and seizures, but it's not the same as in public. And administrators can search students without a warrant, and courts have kind of ruled in favor of that most often as well. Here we have some landmark court cases for our student rights in Busink versus Woodland School District, 1998. This student made a website and complained about certain things that the school did and didn't like. The school didn't like that, punished the student, but the courts actually ruled in favor of the student and allowed that speech to continue and said that the school board can't suppress speech that just doesn't agree with what they're doing. And another case in Bethel School District versus Fraser in 1986. The courts actually, in this case, ruled in favor of the school district suppressing that speech. That was lewd, vulgar, defamatory, or offensive. They ruled in favor of Fraser, but the Supreme Court overruled that. This is a great example of that. Some courts will rule in some favor of some side, and it could be overruled up to the Supreme Court. It all depends on what kind of justices you have in that particular system. So right here I have teachers' rights, and underneath that it says know your rights. It's a good idea for teachers to have a good understanding of educational law. And certain courts have ruled in favor of free speech, and some have ruled against it when it comes to the teachers. In one, Garcetti versus Ceballos, the courts actually ruled in favor of or ruled against free speech for the teacher, so that once you become a public employee, you're forfeiting some of your abilities to carry out free speech. We also have our Lax versus Ferguson Reorganized School District that I'll get on to the next. So teachers, bottom line, need to be careful what you say. Some courts will rule in your favor, as you saw before, and some courts will rule against you. Garcetti versus Ceballos is the case that says teachers lose some regards to free speech when they become a public employee. And in the other Lax versus Ferguson Reorganized School District in 1998, Lax ruled in favor of the school district terminating the contract of a teacher for the lack of censoring student speech. So not only do you have to worry about what you say, you also have to be worried about what your students say as well. And your determination of their free speech is just as important as your determination of your own free speech. So this is a section that I thought was pretty interesting over school safety. It says, can a school authorize personnel to carry a deadly weapon? So in our state of Ohio where we teach, they cannot, according to Gabbard versus Madison Local School District. We're going to learn in the next slide that there's a certain group of personnel that are allowed to conceal a weapon. There's been a lot of talk in our state for those teachers to carry weapons, to be trained. It has not happened yet. And most recently, in the Madison School District in Middle Ohio said they're going to certify some people to carry a weapon, and the court said, no, you're not. So this Madison Local School District in Ohio, they experienced a school shooting in the year 2018. And if you notice, if you're not familiar with the courts, but this says this was settled in 2021, the courts take a long time to get determinations, and there's a lot of stuff that are put in place there. So in 2018, the school experienced a school shooting where 4 students were hurt. The following year, they equipped certain staff with deadly weapons, in which the board determined would help the safety of their students. The case made to the school, and the courts determined that the school does not have that ability. And the court said the only person that authorized to carry a deadly weapon would be somebody who completes a basic peace officer training or has 20 years of peace officer training themselves. So as of 2023, right now, there are no laws that suggest that teachers will be equipped with a deadly weapon and it would still hold up in court. So this slide is on the equitable practices that we have in our school system. You know, those equity and equality have been used a lot in the last, let's say, half decade to decade, and really discrimination and equitable practices in the forefront of a lot of things in education. So discrimination in the school system has broadened to include new gaps over the last decade, and we see this in our lives here in the whole entire United States. I would bet, and they'll be ever evolving even more. So one of the things with discrimination is freedom of religion, and those practices have ruled in favor of the student at times, and again ruled in favor of the school. So on the next slide, I'll show you a specific example. So this court case, Santa Fe Independent School versus Doe in 2000, is an interesting take on freedom of religion. And honestly, I've seen this specific case be brought up in a number of different areas, and even one locally here in the state of Ohio as well. So there was a situation where the football team of this school system wanted to have a prayer at the end of their football games. And this was voted on and approved by the board. And that's where the courts kind of drew a line in the sand with the freedom of religion. And the schools themselves can't endorse prayer or other religious activities. If the students led this particular prayer, if an outside source led this particular prayer, that would have a little bit more ground to stand on. But since the school certified this particular activity, that's where the court said that does not apply to the freedom of religion. So I think we're pretty much all familiar with the idea, Individuals with Disabilities Education Act. In 1975, that opened the door for special education rulings in the court system. And a lot of these rulings have ruled in favor of the student in the special education. So each school is supposed to design instruction that is individualized for each special ed student, and that instruction has to be something that forwards their education or improves their education and shows progress in their education. So this this next court case I'm going to show is going to be dealing with the IDEA Act of 1975. So this particular case is fairly new in 2017, Andrew F. versus Douglas County School System. And in this particular case, Andrew F. argued that the school did not offer him individualized instruction that would allow for appropriate growth in his class. The goals that they created did not match the students' goals, and they were often repetitive. And the courts ruled in favor of the student, and it is it is said to be one of the greater cases for specialized rights. And Justice Roberts stated that repeating goals of an IEP is not education, but merely a student buying time to drop out. So the point of that statement is to show that there needs to be some kind of instruction that allows the child to have specific growth. So this next one is about school discipline, and teachers need to be aware of what is appropriate discipline for students. Students have challenged school discipline in the courts. The courts have been relatively consistent with the decisions on school discipline, and I think they relatively joined the school side on discipline. And it took court cases recently as like within the last 20 years that supported a school who used physical restraint and punishment in a specific discipline issue, and they actually ruled in favor of the school in that. So school discipline can vary, and some things to deal with physical and emotional restraint and things like that. So this case is an example of the court's ruling in favor of school discipline over the First Amendment. A student wore a t-shirt with a vulgarity on it, and the school punished him. And this is Boroff versus Van Wert City Board of Education. The court said that the school had the right to punish the student in order to protect other students from viewing the vulgar act. So that's kind of traditionally where the courts will rule. They'll rule for the masses. If you do something that could harm the masses, then the courts will typically rule in favor of the majority and of the other students who do not have to witness this particular vulgar act. So the overview slide talks about these 6 particular topics. The first one was student rights. Students have some rights, and they don't have rights, and you have to really read into the specific situations and be proactive when dealing with any of these particular subsections of these slides. The teachers have rights. In some cases, the courts ruled in favor of the teachers. Some they didn't. School safety. What you should get out of that is only trained employees can carry a deadly weapon in the state of Ohio. As much noise as there has been that said that the state was going to train teachers, at this point in time, there is no training for teachers to carry a deadly weapon inside the school. Our discrimination slide on the bottom here, freedom of religion only works if the school is hands-free. So the school needs to be away from the religious activity, have the students go ahead and orchestrate that activity, but it's only driven by the students. So special education, if you get anything on this, progress needs to be made in the IEP. You cannot just write repetitive goals for the student and not show real growth, but just use the same goals that you can kind of make sure that somebody can check a box. We're looking at specific goals, and the courts have ruled in favor of the students who have not seen actual progress inside the school. And for student conduct, the courts usually rule that the masses are way more important than the individual. So if you want to wear a vulgar shirt to school, you might lose in the courts because of the fact that you are harming the masses, and the masses don't have to view this vulgar shirt because it is a public institution. Now, with all this being said, the courts will rule the way the courts believe. And traditionally, it depends on if somebody is a conservative court, they will rule conservatively. If somebody is a liberal court justice, they'll rule in favor of the liberal agendas. There is not a coincidence why the last 2 presidents have seen the most appointments to judges on any courts, in Supreme Court all the way down to local district courts. So the courts can rule and interpret the Constitution in multiple ways, and you have to take that interpretation from these other cases and kind of make your decisions and be proactive in order to stop future lawsuits and future problems to happen in your school district. So I have the resource slide next, and thank you I appreciate your time. It was really nice to get this information out to you. Looking forward to expanding on some things. I'm very interested in looking at these court cases. So that's something that it is very compelling to me, and I want to get that information out to you. So if you need anything with educational law, please don't hesitate to contact me, and we'll kind of work through what we can together. Thank you very much. In that last slide here, you'll notice the resources that I use for some of those court cases and that information presented in the presentation.